No, it's no problem. Dear colleagues, good afternoon. It's a great honor and pleasure for me to be moderator of the second panel of our event, which concerns the application of international humanitarian law and human rights law by international courts and tribunals. And it's a pleasure to see such distinguished scholars and practitioners in this panel. Following the early discussion, it has to be noted that the relation between two sets of rules in the situation of an armed conflict has repeatedly become the subject of examination in international courts and tribunals. The current practice reveals challenges caused by attempts of simultaneous application of international humanitarian law and human rights law to the integrity of these rules and to institutions seeking to apply them. For instance, we see from the practice that the case law of European Court of Human Rights is quite controversial. The court attempts to resolve the issue of relationship between international humanitarian law and provisions of European Convention on Human Rights in relation to the same event twice. In the cases Al-Jeddah versus United Kingdom and Hassan versus United Kingdom, it comes to completely opposing outcomes. In this regard, there are a lot of practical questions for international courts and tribunals. Some of them have already been discussed in the previous panel. But for instance, it seems to be concern some questions. How to distinguish situations of exclusive application of international humanitarian law or human rights law? Is it possible to apply both branches at the same time? How should norms of these branches be applied together? Does the joint application of international humanitarian law and human rights law decrease the level of protection for combatants because of unclear standards of behavior? What features should a forum competent to apply IHL possess? And in what way, and the most important, and what degree of detail should the fact be established in order to apply international humanitarian law? What are the standards for the evaluation of such evidence? This and other questions will be discussed within this panel, and we hope to see how different forums approach them. Maybe, eventually, it would be even help to find some decision, common grounds, or suggest recommendations for courts and tribunals on how to apply international humanitarian law and human rights law in a situation of armed conflict. Now, please let me shortly introduce our distinguished speakers. The first speaker is Mr. Anatole Cobbler. Unfortunately, he could not join us today here in Sanremo due to other commitments, but he kindly agreed to send us a short video presentation. Professor Cobbler was judge of European Court of Human Rights and now is the head of the Foreign Law and Comparative Law Center at the Institute of Legislation and Comparative Law under the government of Russian Federation. Mr. Wenjie Zhu, Professor of International Law at Renmin University School of Law, Council Member of the Board of the Chinese Society of International Law and EC Member of the Asian Society of International Law. Mr. Peter Kramer, the former Chief of Appeal and former Acting Deputy Prosecutor of the International Criminal Tribunal for the former Yugoslavia. And Mr. Dieter Fleck, the former Director of International Agreements and Policy at the Federal Ministry of Defense in Germany, the Honorary President of the International Society for Military Law and Law of War, member of the Advisory Board of the Amsterdam Center for International Law. Before we start, I would like to know that each speaker has 20 minutes for presentation. After that, we will have 20 minutes for Q&A session. With this, I would like to kindly ask to show us the video message from Professor Cobbler. Thank you. Yes, now.
Dear colleagues, unfortunately, I will not be able to attend physically your workshop due to the professional obligations. However, as a former judge of the European Court of Human Rights, I would like to express some ideas concerning the concept note of the workshop. So I am grateful to the organizers and especially to Victoria Manco for this occasion to speak by telecommunication. The questions that the organizers put to the participants are legitimate, taking into account a contradictory case law of the European Court of Human Rights and in some extent of the International Court of Justice of the last decades. The sad paradox is that the contemporary history in the past 75 years after the end of Second World War, the international courts deal with problems of international and non-international armed conflicts, and the international humanitarian law is applied in relation to the Universal Declaration of Human Rights, to the Convention on Human Rights, or to other covenants as a lex specialis or as an autonomous legal system per se. It's remarkable that 2 years ago, the Steering Committee for Human Rights of the Council of Europe created a committee of experts on the system of the European Convention on Human Rights and its place in the European and international legal order. As a member of the drafting group, I was involved into the drafting the text called Interaction between International Humanitarian Law and the European Convention on Human Rights. Let me share with you some preliminary conclusions of our group. The final version of the general report will be announced in coming days or in coming weeks. First of all, the rapporteurs note that it is a surprise that the case law of the Strasbourg Court features prominently in those discussions. International humanitarian law, as such, is a specialized body of law designed to be applied in situations where the usual process of social ordering have broken down or under threat. In relation to the law of international armed conflicts, many of the primary rules of international law are now codified in the 4 Geneva Conventions or in additional protocol number 1, which have been widely taken by the states. But by contrast, in relation to non-international armed conflicts, much of the law remains uncodified, although there are important provisions in conventional law, notably Common Article 3 to the Geneva Conventions and Protocol number 1. And given that goal, the fact that both international humanitarian law and international human rights law developed in the post-World War period in reaction to the horrors that occurred during the immediately preceding period, it is notable that for a long time the 2 bodies of law developed in parallel but largely separately. That separation has traditionally been explained by the specificity of the field of application of international humanitarian law. International humanitarian law applies in situations of armed conflicts, governing primarily the conduct of hostilities and the protection of persons hors de combat. By contrast, human rights law will apply in principle in times both of peace and conflict, and it is the first statement of the relationship between those 2 bodies that the International Court of Justice said in this famous judgment legality of the threat or use of nuclear weapons in 1996. But more detailed approach is given in the other document, advisory opinion on the construction of wall in the occupied Palestinian territory, where the court underlined, I quote, "The court will have to take into consideration both these branches of international law, namely human rights law and, as lex specialis, international humanitarian law," end of the quotation. The approach of the European Court of Human Rights to situation of armed conflict is not uniform, as you know. From Louis Zido case to Hassan case, there were different stages of different approaches of the European Court. I don't want to enter into details. And the court chose to seek an accommodation between these two apparently conflicting legal provisions through interpretive approach based on the rules of interpretation of in Article 31 of the Vienna Convention on the Law of Treaties. In this relation, the court underlined its previous case law requiring an interpretation of the convention, I quote, "in harmony with other rules of international law, which applies also to international humanitarian law." Varnava versus Turkey. It can only be in cases of international armed conflict where the taking of prisoners of war and the detention of civilians who pose a threat to security are accepted features of international humanitarian law, that Article 5 of the European Convention could be interpreted as permitting the exercise of such broad powers. But the minority in this Hassan case, especially Judge Spano, joined by 3 other judges, gave a partially dissenting opinion, differing from the majority's approach of seeking to address the apparently conflicting legal provision through a harmonious interpretation, so-called harmonious interpretation. In their view, the only way for a state to reconcile its obligations under Article 5 of the European Convention on Human Rights will, with the exercise of the international humanitarian law powers, is to make a valid derogation under Article 15 of the Convention. The conclusions of the Committee of Experts is rather flew. They underline the necessity that any reconciliation must take account of the nature of conflict. It was suggested that an alternative solution to the question of determining conflicts between at least some provisions of the 2 bodies of law is for a state to derogate from the European Convention on Human Rights in accordance with Article 15 of the Convention. For the minority in Hassan, this is the only possible solution under the Convention. It is notable, too, that the Human Rights Committee in General Comment 35 seemed to accept the possibility of states derogating from the right to liberty in conflict situations, including conflict situations outside their own territories in which they are engaged. Even where a derogation is permissible, to my mind, it is not clear how far derogations may be permitted. All of this suggests that the invocation of Article 15 may assist in answering some questions, but it is also likely to raise further questions, and careful assessments would have to be made of its overall contribution to creating greater legal certainty. My personal position can be expressed in 3 points, and I would like to express in summary way these 3 points. Firstly, the norms of the European Court of Convention on Human Rights cannot be applied extraterritorially during an active phase of military operations of an international armed conflict. Here, I accept the monopoly of the international humanitarian law. Secondly, even accepting the Convention's application in these conditions, the norms and principles of international humanitarian law must be taken in consideration as lex specialis. Thirdly, taking in account a particular status of the international humanitarian law as lex specialis, its provisions may affect the interpretation of the convention and, in some circumstances, prevail over convention. But the main conclusion is a necessity to draw a clear demarcation line between two systems. I summarize: no joint venture, no mutual exclusion. A demarcation line is the best solution to my mind. I wish you successful work. Buon lavoro a tutti. Thank you.
I invite back our speakers. And we thank Professor Cobbler for the video message and for setting the stage for further discussion. And now we turn to Professor Zhu, who is going to speak on contribution by the ad hoc international criminal tribunals to the development of international humanitarian law, and especially the problem of taking of evidence. Please, give you the floor.
Thank you very much. I thought I will be the last, but anyway, it's the same. Well, firstly, thank you very much for inviting me to this event. And this year marked the 17th anniversary of the Geneva Convention of 1949. So there are so many conferences in memory of this anniversary. And for me, I'm going to speak about the contribution made by the UN ad hoc tribunals to the development of the IHL. And for me, personally, I must say that I'm very lucky because I was involved in these two tribunals right from the very beginning. So when I recall, because this time I come here and right now I have to speak, so this actually offered me a very good opportunity to review what I did or what we did in the tribunal. And today I just want to share with you some of the examples which clearly show the contribution made by the two ad hoc tribunals to the development of the IHL. Well, it's no doubt that ICTY is quite particular or quite different. Where the ICTY was set up in 1993, and if you count the development of the international criminal law, and then you will see it's very interesting because after the two international military tribunals after the Second World War, that means Nuremberg and Tokyo, where Tokyo sometimes we call it Far East. And then when these two tribunals finished in 1948 with the judgment for the Tokyo Tribunal read in November of 1948, where the judgment is very long. It took 8 days for Judge Webb from Australia to read the whole judgment, which is 1,082 pages. Really, it's very tiring for him to read 4 days. So after that, after 1948 until 1993, when ICTY was set up, and then you can see really it's the international community did nothing during these 45 years. And then suddenly, the ICTY, of course, ICTY was set up in 1993, there was a reason. And the main reason because when the Cold War was ended, and it was very easy for the Big Five, for the Big Five to be in coordination. Because at that time, I was in Chinese foreign minister and I was the person to be in coordination with the legal advisors of the US, of the Soviet Union, no, at that time already Russia, and also with the Great Britain. So I can see where at that time it was really the right moment. It was easier to be in discussion, in coordination. But however, then you can see that the tribunal was set up not by treaties, and because when you look into Nuremberg, were mainly by Moscow Agreement among the four, the United States, Great Britain, France, and the Soviet Union. And also not like the Far East. The Far East, where of course it was set up by General MacArthur, but MacArthur simply carried out some legal document, for instance, with Boston Declaration, for instance, with the surrender document by the Japanese government. But however, the ICTY is totally different. It was set up by the UN Security Council. So for this reason, and then you can see it's so beautiful, because in order to solve the issue, that some of the countries might be the party of the rules of law which will be applied in the case of ICTY, but some of them are actually not. And then where to solve this problem, and then where the United Nations has to do some work, and then where it came out in the report by the Secretary General of the United Nations saying, in this case, the ICTY can only apply the rules of international customary law. So and then if you look into the statute of the ICTY, of course, certainly you see Article 2 about Geneva Conventions. So it's crystal clear at this moment that Geneva Convention of 1949 is a part of international customary law. So and of course, in the process of the ICTY, because of this, we may call the report of the UN Secretary General as travaux préparatoires. Because of this, and then for the ICTY is obliged to apply only the rules of law, which is no doubt a part of international customary law. When this is really beautiful, of course, when this is the first time for such determination. And of course, there are many other things, again, for the setting up for the tribunal. And the UN, ad hoc tribunal, ICTY, was set up in 1993. And then when the first case is Tadic, and in that case, of course, you have some facts, and of course, you also have to argue what kind of rules of law should be applied in that case. And then suddenly in that case, I must say that the defense lawyer very smart. The defense lawyer first will challenge the legality of the establishment of the tribunal by saying the tribunal is unlawful. Why? Because it's decided under Chapter 7 of the UN Charter, but actually, Chapter 7 of UN Charter did not authorize. This is certainly logic. Anyone or everyone must respect law, and then the UN Security Council should also. And then if you speak about what law the UN Security Council should apply, certainly it's the UN Charter. And then I still remember that after the motion presented to the tribunal by defense lawyer, really day and night, we were just there, we're doing some research. And then, of course, you have to do some research about the Chapter 7. And then for Chapter 7, the first article is 39. And in that article, it begins by saying that the UN Security Council can determine the existence of threat or breach of international peace and security. So here, determine, that means where the UN Security Council can judge and also can decide if a breach or if a threat of international peace and security exists. And then if it exists, and then the UN Security Council can apply certain measures as in Article 41, Article 43. Article 41 is concerned with the measures we call peaceful, where setting up of tribunal is certainly peaceful measures. But however, in that article, you don't see any particular measure about the judicial means. And then we did some research. We find that when the Security Council determines the existence, and then when the Security Council can take some measures, include, the wording of include shows that all these measures here are just example. It does not exhaust any necessary measures that the Security Council deem necessary where in order to carry out the mandate of Article 39. So it's just beautiful way to see all that. And also where, let's say about Article 2. Article 2 is about the grave breach of Geneva Convention of 1949. But however, until that time, is that the whole convention, the whole body of rules of Geneva Convention of 1949, is it only applicable in international armed conflict, or is it applicable in both international and non-international armed conflict? We don't know. Until that time, that means until the first case of Tadic, when nobody ever said so. And then when the defense lawyer of Tadic, well, he's always very smart. And then he said, well, we challenge. We challenge because in the Tadic case, where some of the acts alleged are actually that taking place in non-international armed conflict. And the Geneva Convention of 1949 cannot be applicable in non-international armed conflict. Of course, where Geneva Convention of 1949 is the legal document negotiated and concluded by states. So we have to look at the will of the states at that time to see if the states are willing to have the whole body of Geneva Convention applied to both situations. And of course, we have Common Article 3. But besides Common Article 3, so, and of course, where grave breach is a clause which is connected with many other concepts, such as protected persons, such as protected properties. Anyway, then where the appeals chamber in that case ruled, the ruling is where for the whole body of international Geneva Convention of 1949, it can be only applied to international armed conflict. So afterwards, when we, the prosecution, would like to apply Article 2 of the statute of the ICTY, and then we have to, first of all, demonstrate that all these acts took place in an international armed conflict. That's really very beautiful. And again, for Common Article 3, when this is another very beautiful example about Rwanda, where we all know very much about what happened as genocide in Rwanda. That was where from April to July, where in Rwanda, that was very sad, in which where almost 1 million people got killed, were Tutsi, and also where some of them are Hutu, were victims. Of course, it's no doubt where all that happened during non-international armed conflict, and also genocide. And the beauty of the establishment of the ICTR is that actually it was the Rwanda government which took the initiative, which wrote many times to the Secretary General of the United Nations asking to have justice done, asking for the punishment of those people who are responsible for the killings, for the genocide, where during non-international armed conflict of 1994. It was really beautiful if you think how strongly the concept of state sovereignty stands even today in the field of international public law. And then you can see when the government of Rwanda really goes very far away. But however, in adopting resolution 955 in November of 1994, Rwanda government was against this resolution. But the reason, you have to look into the reason, but the reason is not that Rwanda government did not want that institute. It still wants the institute of ICTR. The reason the Rwanda government did not like very much that resolution is that where Rwanda government did not agree that the maximum penalty will be only the life imprisonment. The Rwanda government would like to have death penalty. But however, with what has already developed so far in the field of international human rights law, or in general international public law, and then where death penalty cannot be something where all the members of the Security Council can reach consensus. So where for the first time, and then you can see Common Article 3 and Additional Protocol 2 of 1977, for the first time was criminalized into the statute of the ICTR. That is really very beautiful. Well, anyway, I must say that for me, myself, it seems that it's not easy to talk after the lunch, but I will try. Yeah. And anyway, in my, really, I consider myself very lucky because I got myself involved in the practice of ICTR and also ICTY. And really very lucky because at that moment there are so many legal issues which were touched upon, which were raised out for the first time. And when you speak of the development of the rules of law of international humanitarian law, there are so many examples. And there's another one piece of examples which is very interesting. It's actually about the ICRC itself. And in one of the cases where it's really very interesting, I think where this case is, that is Mujij. You know where at that time things when the whole world was very interesting about what was going on in the ICTY. So the cases were broadcasted directly, and some of them with 5 or 10 minutes in delay, but broadcasted directly. And then where suddenly in that case, when that case was in trial, and then where many other people in the world, of course, were just watching. And then one of them happens to be someone who was employed by the ICRC. And then when that one sought accused, and then he said, wow, this guy I know. I know him, I know very well how cruel he was when he treated the detainee. And also it happened that that was the person who has the heart for justice. And then he said, he called the ICTY, he said, I like to come to testify before the ICTY. I know clearly what behavior of that person is. I would like to offer all I know about him before. That means where he would like to testify where as witness. Of course, where this is very good. But however, at the same time, another new issue was raised. That is about confidentiality of the ICRC. ICRC was there ever since 1863. But for the first time where the protection of confidentiality, I don't know where is put in danger or anyway, this is the first time that, of course, we all know about ICRC where for humanitarian, for where being neutrality neutral. And also it's quite true if ICRC is so popular, is very much welcomed. For instance, where during genocide of Rwanda in 1994, all the other NGO were simply put away except the ICRC. Why? Because of its, how to say, customary practice, neutrality, confidentiality, where anyway, the ICRC still remained in Rwanda. So where, of course, where for the ICRC, when the whole ICRC was mobilized, where to face and also to discuss how to solve the problem. And where to put the story very short, because I see time running. And to put it very short, and then when the tribunal, this is also very beautiful, the tribunal has to consider the very nature of the ICRC. Then the chambers concluded that the confidentiality is something connected with life and death of ICRC. And it's so crucial for carrying out the mandate of the ICRC. And then where the ICTY decided that that person, even he has the heart for justice, should not be called to testify before the chambers. And also, the story did not stop here, because just when that case took place, we also discussed about setting up of the ICC, International Criminal Court. And at that time, there were PrepCon. We called PrepCon in New York. And then, of course, we diplomatic conference in Rome of Italy. And then where that case tells the world that it could also happen in the case of the ICC. And then we're in the rules of procedure and evidence, and then it's clearly defined for the ICC that ICRC cannot be obliged to testify before the ICC. And for me, where of course where I also regarded where as one of the pieces of development by the ad hoc tribunals to the development of international humanitarian law. Well, anyway, there are so many, but I think I must stop because where the time is running. Well, anyway, where thank you very much for inviting me, because when this is really a very good opportunity for me to review some of the things where I witnessed where in that tribunal. It was so beautiful, where for whatever legal issues, for instance, for bargaining, where pleading of guilty or not guilty, where we just discuss it. Then you can see the clash between Anglo-Saxon lawyer and the continental lawyer. That is really very beautiful. And also where, for instance, where today it's so common, we have courses and lectures of international criminal law all over the world. But in 1993, actually, where this was something new, where, as I said, after 1948 until 1993, nothing happened in that field. So the world did not prepare for that. When I was in the tribunal, I see that clearly. Just look at the judges, 11 judges. We have, for instance, where honorable, where I have great respect for him, where Anthony Cassese, who was also the first president. But Anthony Cassese, if we look at his background, public international law, and Chinese judge where Li Haopei, also public international law. And then you have the other judges of criminal law. For instance, you have Judge McDonald, who came from the United States, who is very kind and also has a lot of experience because before coming here, he was a judge in Texas, 13 years, but however, as criminal law. So in 1993, you did not see any judge with public international law and criminal law combined. Not like today where you can go anywhere and then you can find. But all these judges, they are devoted so much. For instance, for criminal law, I still will remember clearly, because at that time I was in chamber. I still remember clearly where they have so much dedication. They came and asked, well, what is it, the Charter of the United Nations? What's the role for the UN Security Council? Because they have criminal law. When they deal with criminal issues, procedure or subject or merits, well, it's so experienced, but however, about the public international law, really something new to them. But however, you can see really it's great. They learned and also they're very quick. So today, when I say that what contribution the ad hoc tribunal has made to the development of IHL, and actually, I would like to say these are the contributions made by the judges, by the tribunals, by all of the staff, the personnel of the ad hoc tribunal to the development of international humanitarian law. So thank you very much. I hope I did not make you sleep. Thank you very much.
Thank you very much, Professor Zhu, for your interesting report. And now we come to Mr. Kremer, who is going to raise in his presentation the issue of application of IHL and European Convention of Human Rights norms in non-international armed conflict. Please.
That was the original attempt, and then Victoria asked me to deal with the facts of some of the cases and show how facts are important. I'm not an academic. I'm not a human rights lawyer. I've spent my public career as a criminal lawyer, primarily working for the prosecution. The last 10 years in the ICTY, but also managing the Canadian War Crimes section for 6 years. So I have touched on international humanitarian law, and to the extent that human rights is part of it, touched on human rights law. Criminal law has human rights attributes as well. And the one thing that I found when I started to think about whether I could comply with Victoria's request was the facts drive the decision. You can tell by looking at the facts of the 3 cases I'm going to discuss what the outcome is once you just get back by the fact situation. The 3 cases that I've selected are Al Jeddah, Hassan, and Sadar Mohammed. And factually, they're a little bit different. The legal discussions are different. It's clear Hassan is dealing with international armed conflict. Sadr Mohammed is clearly dealing with an international or non-international armed conflict. And Al Jeddah, they never say. But I think the answer is it was, at the time of his arrest, a non-international armed conflict. And the problem with the Al Jeddah decision, in my mind, is that the question posed was a very technical, legal question on the scope and direction of a UN Security Council resolution and whether it created an obligation for the detaining force to intern someone, and they use the word indefinitely, which isn't the case, for security reasons. But I had a whole script prepared talking about law, but I like facts better, so I'm going to get right into the facts, and we'll see how much time it takes, and I'll give you a conclusion. Fact number one, Al Jeddah is a British national. That's a bad fact for the government. He was on his way to Iraq when he was arrested in Dubai based on information from the UK on the September 28th. He was arrested and interrogated by UAE intelligence officers and released 12 hours later. He travels to Iraq on the 28th of September and isn't arrested, or isn't arrested, maybe too much, but one may say he was arrested because there's an issue as to whether or not this is a law enforcement issue as opposed to a NIAC issue. He was taken into custody on the 10th of October 2004 when he was at his sister's house in Baghdad. He was arrested by US soldiers acting on UK intelligence, taken to Basra in a UK aircraft, put in a detention facility run by the British, and he was interned until 30 December 2007. 3 years, 2 months, 20 days. Bad fact number 2 or 3 or 4, and they keep piling up. The reason for his detention was imperative reasons of security, recruiting terrorists, facilitating travel of explosive experts, conspiring to conduct attacks against coalition forces, conspiring to smuggle high-tech detention equipment to use against the coalition forces. But the question I raise as a prosecutor, knowing how flexible it is to prosecute a conspiracy, why couldn't they get their act together and start a prosecution against them in 3 years, 2 months, and 20 days? They obviously had tremendous information, and they could either prosecute them or not, because this is all, in theory, it's got security components, but it also has a great base for prosecuting. At the end of his detention, there wasn't one criminal charge filed. Another bad fact. When it gets to the internment facts in Al Jeddah, there is no specific information as to how he was processed, how he was dealt with, what the substance of the various periodic assessments were as to whether he still was a security risk. For all we know, the terrorists may have disbanded. For all we know, the explosive expert may have been killed making a bomb. There are all sorts of facts that you would say, wait a minute here, what's the risk factor on each of these points? No indication. Next bad fact, British national, December 14th, 2007, they revoke his citizenship. He becomes stateless. And then on December 30th, 2007, they release him. So looking at this as a prosecutor, or just a lawyer with an inquisitive mind, I would say, I know what the result is. There has been a violation here. The question is, how am I going to get there? And because of the question posed by the parties, they were sort of put in a trap. And I'll show how the trap was created. They have a long list, 12 paragraphs of the history of events in Iraq. But there's little that's relevant to the period of internment. They start with the attack on Iraq, the occupation, and so on. And it's very, very detailed. But it's entirely irrelevant, other than the fact that at some point in time, when he was arrested, you had to figure out whether it was an international armed conflict, a non-international armed conflict, or a police action, domestic support for the new provisional government. Then we have a new constitution in, occupation ends the 28th of June 2004. He's still in Britain. We have a new constitution, 19th of May 2006. And there's provision for judicial review of detentions. But there's no discussion about what was happening to him vis-a-vis the new provisional the new constitution and his security detentions. And probably the biggest bad series of facts are the reports to the UN by the various groups, non-NGOs and so on, of HR violations, detentions of thousands without due process. 13,571 detainees, of which the Americans had all but 85 and the UK had 85. That's probably the only good fact the UK has, is they have a small number of detainees, although they don't say which are held as POWs or combatants and which are held as by the security forces for the purposes of concerns about security. So we start with Mr. Al-Jeddah, who's in jail for, or in custody, detention for 3 years, 2 months, and 20 days. Now we go to Hassan. March 20th, 2003, UK-USA invasion. April 5th, 2003, Basra is captured by the UK. April 9th, 2003, the US captures Baghdad, and the major combat operations are determined to be complete on the 1st of May, 2003. Those are essentially the dates that impact on a determination of the Hassan case. The UK at the time had been arresting Ba'ath Party high-ranking members and detaining them. Iraqi militia, on the other hand, were arresting and killing them. So the applicant, Mr. Hassan, who was a Ba'ath Party official, goes into hiding and leaves his brother to watch the house with his cousin. So on the 23rd of April, the UK go to arrest the applicant, Mr. Hassan, not the person who's, and they found his brother, arrested him, and they also found some documents relating to the Ba'ath Party and firearms. There was, before the provisional government was set up by the Americans and the Brits, an agreement on the 23rd of March 2003 detailing that the Geneva Conventions were applicable. And the analysis, and the facts on Mr. Hassan, even though he's only really in play for 9 days, go on for 9 pages. And that shows how this was a court with a purpose. They wanted to come up with the result. There's a memorandum of agreement that says that the Geneva Conventions will apply. international armed conflict, Geneva Conventions will apply, there's the occupation. It has the usual procedures mentioned vis-a-vis the screening and the periodic reviews and so on. And then the court goes to great lengths to confirm that Tariq Hassan was handled according to procedure. The first interview, recall that he was taken into custody on the 23rd. On the 23rd, later in the afternoon, was his first screening interview. On the 25th of April was his second screening interview. And after the screening process, it was clear that although he was initially in the default category of prisoner of war, at the end of the screening, he was moved to the civilian detention facility. So that was within 38 hours. He was cleared of being a POW, and then on April 25th, he goes into the civilian facility, and there are no complaints based on later investigation as to mistreatment in terms of his arrest or during his internment. There were no interrogations. On the 24th of July, 2003, they decide it was a mistake, and he was released as part of a bulk release of inmates prior to the end of occupation on the 1st of May, or the 001 hours on the 2nd of May, 2003. So those are the facts, pretty simple facts. In custody for 9 days, mistaken identity, not a terrorist, no reason to be concerned, not a combatant, and he's processed quickly and efficiently and released. And everything about his release is examined in great detail. He was released in accordance with the policy that they had for release. And this is the first case, and this is what's important, where the representative state, the UK, has requested the court to apply its obligations under Article 5 or in some way to interpret them in light of the power of detention available to it under IHL. This didn't arise in Al Jeddah. The question was not even asked. It was a very narrow question about whether this UN Security Council resolutions gave rise to obligations or authorizations. And if it was obligations to detain for security purposes, it had to be based on a specific declaration to that effect. They didn't deny that it might not be possible for the UN to do it, but they said it wasn't done in this particular case given the construction that they followed. So Hassan is a case, again, when you read the facts, you know what the result is going to be. So now Sadar Mohammed falls somewhere in between. Let me just find where I've got those facts. As I say, I think it's here. Okay. Now, Sadar Mohammed deals with Afghanistan, as you all probably know. And in this particular case, there was a newly reconstituted government assisted by foreign armed forces of the International Security Assistance Force, ISAF coalition, fighting against non-state actors, namely the Taliban and like-minded factions. They had a broad mandate throughout Afghanistan, but always in a supporting role of the government of Afghanistan. who maintained the political direction of the campaign. But in reality, in remote and rural parts of Afghanistan, the Afghani government presence or the capable local security forces were non-existent. And the ISAF contingents conducted security functions unilaterally. That said, it's not discussed in detail whether the particular situation is one of policing or security policing or one of non-international armed conflict. It is agreed, I think, that at the time in Iraq there was a non-international armed conflict. Now, in terms of Mr. Mohammed's capture, he was a suspected Taliban commander, and he was arrested in a military operation on the 7th of April, 2010. He was originally held for 96 hours under ISAF policy, 3 days, but due to the desire to gain intelligence, he was held for a further 25 days under the UK's national caveat to the ISAF policy for the stated purpose of military interrogation. I think it's conceded that detention for military interrogation violates both military norms or IHL norms and Article 5. They couldn't transfer him after the interrogation because the Afghan authorities' detention facilities were overcrowded, and the UK also refused to transfer to certain Afghan prisons where they had reason to believe that there was mistreatment of inmates going on. So on the 25th of July, 2010, he was transferred to the Afghan authorities, good fact for the Brits, where he was tried, found guilty, and after an unsuccessful appeal, sentenced to 10 years imprisonment. So here's a guy who's in jail for 28 and 81, 109 days. So he's closer to Al-Jeddah as opposed to Mr. Hassan. The safeguards regarding internment are all found in the standard operating procedures and instructions and other Ministry of Defense and governmental rules and regulations which the Chamber deals with at length. The question here is, again, what's the likely outcome? Here the question was, for a non-international armed conflict, is there a legal basis upon which the detention for imperative security reasons can be substantiated? The argument is not based on IHL, which our panelists earlier today had suggested might be on a rocky footing. But so, and I think they made a good choice. They basically argued that the context of the conflict, the Security Council regulations and supporting documentation, the UN Charter and the obligations of the Security Council, when looked at objectively and holistically, support the argument that the UN Security Council resolutions that are in play contemplate and authorize detention for security reasons. And they looked at the regulations and procedures to determine whether, in fact, those procedures were consistent with the Geneva Conventions for International Armed Conflict as a minimum protection, which in fact the stated objective of the rules and regulations was to have that on-the-ground requirement for the military. And they did. But that said, they found that although the initial detention and review process had been appropriate and lawful, after a period of time for Sadr Mohammed, his detention became unlawful according to the criteria because at some point the review committee ceased to be independent. And so they did an interesting thing. They said, on this legal argument, we're prepared to find a second category for detention contrary to Article 5 in theory, and that is based on Security Council regulations. The earlier one, Hassan, was IHL, and the third, derogation. So that in the non-international armed conflict where the force is acting outside of its jurisdiction, it can be found responsible if there is no basis in law for the detention and if the procedural norms aren't complied with. And that's what they found, and they found a violation. But they suggested the violation is based on not only the procedural norms vis-a-vis international law, but also vis-a-vis the European Court of Human Rights. And that compromise may be, in my mind, the road forward to a solution, because the European Court keeps its role. It's not a black and white situation. And to the extent that this is an international body that's providing the structure and the guidance, it's something they can live with. Then we're left with the question about the NIAC in one place with no foreign actors per se. Could be foreign actors as the opposition. Then, in my mind, it's domestic rules for a starter. And to the extent that it becomes a NIAC over a period of time, NIAC rules, I think one can argue that, NIAC rules can inform the domestic rules and their interpretation as to whether there's been a violation. And I think the lesson learned from all of this, and then I'll shut my mouth, is that there is a way for the military and the states to move forward without having to cry chicken. I think that they can ask themselves, what is the minimum level of protection that we should build in to protect our forces, to protect our civilians, and find a way to do that. The European Court of Human Rights has had derogation cases. They've listed commentary on the scope of the derogation and the fair procedure norms that have to be followed. There is enough information out there that one can make a serious start to sort of finishing the circle on this issue. And so I hope this case goes to the European Court of Human Rights, and I hope the outcome, as I predict, is there. The facts are okay, but they could be just a bit better. Anyway, thank you very much for your attention.
Thank you very much, Mr. Kramer, for your analysis of these important cases in the light of our topic and for your outcomes. And now we give the floor to Mr. Fleck, who will introduce us to a comparative analysis of the practice of different courts and tribunals and will focus on the impact of international humanitarian law on the application of human rights. Please.
Thank you. Let me first of all express my gratitude to our hosts and organizers for making me part of this intriguing exercise on a topic where I did not feel very familiar with, but soon agreed and quickly agreed that yes, this is an open question which is high time to be to shed more light on it. I was particularly intrigued by the questions raised by our hosts in the project description by two sentences, two questions. If, and I quote, if IHL is applied in relation to the convention, to the European Convention, as a lex specialis, what impact does the convention have upon IHL rules in this regard? How does the application of the convention and IHL as a lex specialis differ from the application of IHL per se? And I would suggest that both sentences may and should perhaps be turned around. We should rather ask ourselves, what impact does IHL have on convention rules in this regard in an armed conflict? And how does the application of the European Convention or the American Convention in other regions and IHL as lex specialis differ from the application of the convention, of the relevant convention per se? This may be the more practical question, and as we had an excellent discussion this morning on the general relationship between the two branches of international law and also on the issue of extraterritorial application of human rights, I do have the feeling that with the convincing arguments made by the previous speakers this morning, and looking at practice, it's possible to develop a common consensus here, a common general feeling how to deal with this matter in practice. Always consider the fact that soldiers in the field, they're always quoted as being simple soldiers, but they're not simple. And what they do not care of is to know where different law comes from. They do care, however, very much about the question what the law is and how it can be implemented into practice. My specific question is here on the substantial legal limitations of individual human rights in times of armed conflicts. How can we phrase them? How can we better understand them? And if it's not possible to draw general lines on this, then yes, we have to admit that we have to go into jurisprudence. And not only jurisprudence as of courts, the topic of our panel here, but also jurisprudence of general other human rights bodies as well. This might be very helpful, and I would suggest to look into the Inter-American Commission on Human Rights, as well as the Inter-American Court on Human Rights, the African Commission and the Court of Human Rights, the Arab Human Rights Committee established in 2009, and also, yes, on a global scale, the Human Rights Committee established under Article 28 of the ICCPR. I cannot do this within 15 minutes left, and I am too eager to listen to your critical comments because my presentation is incomplete, and I'm really asking for help, especially help by the neighbor sitting next to me with his remarks on derogations, which is intriguing me, and with other remarks you made. So I divided my presentation into 4 parts. First, let's try to have a general look at jurisprudence related to armed conflicts. Do the cases decided so far offer a full picture of open issues in this relationship? Certainly not, but we have to identify the gaps then. The second area of interest would be a comprehensive comparison of the jurisprudence of these different bodies. To what extent have they helped to clarify the complex relationship between human rights law and international humanitarian law as two distinct but interrelated legal branches? And third, the standards for legal proceedings need to be scrutinized. Are they comparable? Are they sufficient to meet contemporary challenges? And finally, of course, we are bound to try to draw some practical conclusions. The cases related to armed conflicts cannot easily be found in the jurisprudence of the European Court in Strasbourg, so I started with the Inter-American system. But let me make a remark right from the beginning. The fact that certain human rights may be derogated in times of emergency, this is a recurring fact in many, not all, the regional conventions, is, in my opinion, of minor practical importance. First, those human rights which have been formally adopted by the international humanitarian law provision, Article 75 of the first protocol, a provision that may now have even reached customary law status. Americans may offer some objections, and Israelis too. They have entailed that these so adopted human rights have become derogable. This has been by the It was also the conviction of the negotiator at the time. I had a good discussion with Michael Bote on this, and he remembered Caillou Page. They were proud of getting something transported into the additional protocol, which would now be non-derogable. In former times it was. So let's discuss on this also in terms of the Hassan case you referred to. State practice has also shown that, and this is a remark which has been made by Thomas Bergenthal, very often adapted in state practice. States are shy or not interested in making such derogations, and they're sometimes even hesitating in calling an armed conflict what it is. This is a tragic history which we recently experienced again in Syria. For international humanitarian law, the range of applicability is limited. Let's accept that we have a limited area of application. This is definitely armed conflict. And armed conflicts, international and non-international armed conflicts, come in Article 3 of the conventions, which even refer to parties of a non-international conflict, to both parties with a capital P. This is something which was possible in 1949, which is never appeared again in the years afterwards. Warring parties may be interested to treat this as internal disturbances, but yes, we had the great man Jean Pictet in his commentary after the 49 conventions. He insisted on the fact what is inhuman in controversy. A similar sentence appeared again in Tadic. But this sentence was not as courageous as the sentence expressed in 1951, or when the commentary was first published. The Inter-American Commission on Human Rights has decided in Avilan, a case in which extrajudicial executions during a non-international armed conflict in Colombia had to be investigated, that the non-derogable guarantees of the right to life set forth in the American Convention applies along with and is informed by the provisions of international humanitarian law for internal hostilities. Such a clear statement is missing in the Strasbourg jurisprudence generally. In court, the American Commission confirmed that both systems of international law, humanitarian law and human rights were applicable in the armed conflict between Grenadian nationals and United States military forces in 1983, very old cases. And the Commission held that the concurrent application of the two systems, nobody spoke of lex specialis, but concurrent application of the two systems of protection is inevitable, and that it is competent, therefore, the Commission is therefore competent to investigate the procedures taken by the parties involved in the conflict. The Inter-American Court on Human Rights has specified this jurisprudence in Las Palmeras. they said that although the Inter-American Commission had broad faculties as an organ for the promotion and protection of human rights, it can clearly be inferred from the American Human Rights Convention that the procedure initiated in contentious cases before the Commission, which culminated in an application before the court, should refer to rights protected by the American Convention, and that the Commission and the court did not have the competence to determine whether a given act was in violation of the Geneva Conventions. But this was again limited by another case, Bamaca Velasquez, that this does not preclude taking into consideration provisions of international humanitarian law in order to interpret the American Convention. In this context, it should also be considered that human rights bodies have a responsibility to investigate those limitations of human rights in armed conflicts, which may apply under the lex specialis rule of international humanitarian law. The European Court on Human Rights never was as explicit on the issue. And in Chechen cases, for instance, the court applied human rights without investigating specific consequences that might derive from the existence of an armed conflict. This might have been influenced by the pleadings of the parties at the time, but I will remind you then that the Russian Constitutional Court had no difficulty years before to state that the Chechen conflict had even reached the specific threshold of a non-international armed conflict according to additional Protocol 2. This statement was maybe not taken into consideration by the court in Strasbourg. However, in Loisidou, Alazzani, Hassan, the European Court rightly confirmed that the European Convention cannot be interpreted in a vacuum and should, as far as possible, be interpreted in harmony with other rules of international law to which it forms part. This is a statement as general as it is, which is lacking clear explications how would this to be translated, and should this be to be translated into the applicability of international humanitarian law as well. As for Hassan, I was very intrigued by your explanation, Peter, but I am stumbling over the paragraph 107 of the decision, where the court, in my opinion, made two very obscure statements in one paragraph. First of all, they said that it is necessary for a formal derogation to be lodged. The provisions of Article 5 will be interpreted and applied in the light of the relevant provisions of international humanitarian law only. But why did they refer to a formal derogation? If this is true, what I just explained from the understanding of Article 75 of the First Additional Protocol, there's no derogation, in fact. There is a possibility for derogating human rights in peacetime and in times of internal disturbances for law enforcement activities, but not in active hostilities. And the second and more confusing statement, which I read here, is that international humanitarian law can be applied only where this is specifically pleaded by the respondent state. What obscure statement is it? Isn't the court obliged to know the law? And if the application of the law depends from certain facts, it's the freedom of and the obligation, the noble task of judges to ask the parties how they interpret it. And if they do not ask, at least I think this is a lack, a real weakness of the, revealing a real weakness of the jurisprudence of the Strasbourg Court. Recently, Anissa Bilal, an excellent collaborator of Marcus Sassoli, explained in her briefing for the Security Council on the occasion of 70 years Geneva Conventions that there is a need to mainstream IHL in all pertinent legal systems and to build bridges between implementing institutions to create efficient, coordinated, and more integrated responses to prolonged situations of violence. I think we cannot agree more on such a statement, and we immediately feel that this has a relevance for forced disappearances, for operational detentions, likewise for destruction of homes, and this is a topic of increasing significance for military operations, especially in peace operations when it comes to robust peacekeeping. I shouldn't go into details here, but I would be prepared to refer to mistakes made in Kosovo under the authority of the Security Council. Let me come to my conclusions, which may be controversial, I hope not, but will certainly need support and critical questions from an informed audience. First, I would suggest that the concurrent application of the two systems of protection, human rights, international humanitarian law, requires in armed conflict situations to take international humanitarian law into consideration when interpreting and applying a rule of human rights law. Second, as the use of lethal force consistent with international humanitarian law is generally not unlawful, something which has just been reaffirmed again by the Human Rights Committee of the United Nations. The European Court of Human Rights is called, in my opinion, to apply international humanitarian law to convincingly decide whether the use of force is absolutely necessary in accordance with Article 2 of the Convention. If it doesn't perform this examination, then the court cannot give a professional judgment on the application of the human rights obligation. Third, the same applies, in my opinion, with regard to lawfulness of detentions in accordance with Article 5 of the European Convention. And fourth, human rights bodies may and should thus provide support to ensure respect for international humanitarian law. Lastly, the reluctance of the European Court to qualify a situation as an armed conflict negatively affects the convincing application of human rights obligations in those situations. Thank you.
Thank you very much, all the panelists, for their presentation. And now we may turn to the floor to the audience, and also encouraging our internet audience to ask questions. Please. Yes, Judge Tizmuhamedov, please. Do you have a microphone? Yes, please.
Dita, is it on?
I think that we can use this microphone because of our internet audience.
Dita? Yeah, that reference to the Constitutional Court reminds me of an interesting chat we had years back after this judgment was delivered. But I'm just wondering, are you implying that European Court of Human Rights should have taken note of a judgment by a national judiciary in which it recognized that additional Protocol 2 applied to a domestic violence? The court said, although not very explicitly, but it basically said that additional Protocol 2 was not taken into account of, which means that it said that the protocol should have applied. And the court, as you remember, was not the only authority. Actually, all branches of power of government made statements to the effect that what was going on in the North Caucasus amounted to a non-international armed conflict. I'm not sure that the French did that with respect of Algerian War of Independence, or the British with respect of the troubled times in Ulster, and think of other examples. Now, If a state derogates from European Convention of Human Rights or ICCPR and says we derogate from Articles 5, 8, others, does it have to say then that the other body of law applies? That we don't apply European Convention, but we do apply IHL? Because when Ukraine derogated from both European Convention and ICCPR in 2015, they did not say that they were moving into the realm of IHL. Well, maybe but that was because in 2015, Ukraine still qualified what was transpiring in the East as a counter-terrorist operation. And you know that in 2018, they passed a law which effectively makes it an international armed conflict. So if a state derogates, does it have to say in the act of derogation, we do not apply this body of law, but now we apply the other body of law? Thank you.
Well, thank you very much. I fully agree with Dieter that the statement in the Hassan decision is very strange. I wonder, Uranovid Kuria is perhaps not the essential issue, but the essential issue is that it replaces somehow the reasoning of the court, in my view, is that it says, okay, I no longer ask for a derogation, but somehow I apply another body of law only if a state explicitly says so, while if the state wants to apply the full extent of human rights law, then I apply the full extent of human rights law. And this shows something I didn't mention this morning, but which is an additional risk of applying IHL by human rights bodies. It is simply that human rights bodies have another or a quite procedural approach to the applicable law, because somehow they do not really have to tell the soldier what law the soldier has to apply, but they have to find whether the state is responsible of a violation of the European Convention. And obviously, from the point of view of the soldier and the state, such a statement is not very useful, because when the soldier has to know whether he or she can shoot or can detain, they cannot wait until they know whether their government will one day invoke humanitarian law before a court. So this is perhaps the general problem, that specialized international courts have a certain tendency, despite all their invocation of the Vienna Convention and Article 31.3, to give precedence to the law for which they were created, and one can understand that, but this makes our whole debate, it falsifies our whole debate, also because there is no humanitarian law court. Okay, there are international criminal courts, but that's somehow another issue. Thank you.
Can I just make a comment on that? There are several cases out of the European Court of Human Rights that incorporate IHL principles into the decision-making without attribution. You know, there's Ergi, Asayeva, and Finugenov, where they incorporate the test in Article 57 of Additional Protocol 1, quote, take all feasible precautions to avoiding or at least minimizing incidental loss of civilian life, and in the Finugenov one, they actually or in a couple of them, they deal with the use of weaponry that was disproportionate and so on. So they're using it as an interpretive tool. It would be helpful if they would say so. We're doing this. This is part of our package of case law or of law that we can make reference to giving full life to the convention, but they don't say that. And in one of those three cases, I recall they said the question of non-international armed conflict was specifically not raised by the party, and we will not discuss this issue without the party's consent.
May I quickly answer to these intriguing comments? First, Bhaktya, I think any state has a right to make derogations of derogable human rights. And this is subject to law enforcement situations. Your case of the Ukrainian case may have been declared at a time when this was controversial, whether whether there's an armed conflict or not yet an armed conflict. And such a declaration or a derogation made by the state, by the affected state, may have also a de-escalating consequence. In a time when the president of the opposing state even made this very critical remark, well, they crossed the border, but they may have done this by chance. I'm not quoting President Putin here verbally, but I think this was the sense he tried to convey to the public. Was it at the same date, the same time in 2015? So this is the open question. My opinion is, yes, if derogations are possible, they may be used for law enforcement purposes. But if there is an armed conflict situation, conduct of hostilities during armed conflicts, I would stick to the ICRC interpretation of Article 75 of the first protocol and say that these fundamental human rights are now derogable. And as far as Marco Sassoli's remark of tendencies among judges is concerned, I would suggest, and I'm making too provocative here perhaps, but a professional human rights body cannot live with tendencies by judges. He just is, the body is just obliged to realize what's happening here and what is applicable and what is not applicable. So there is a task of human rights bodies to show professional applications of existing law rather than tendencies. And as to Peter, I would suggest that the minimizing use of force in a tough situation is raising the interesting and provoking question, which is totally controversial, of the application of the principle of proportionality. Is proportionality the same in an armed conflict situation, in conduct of hostilities, when we think of collateral damages or so? Or is it different in law enforcement situations in a conflict below the level of an armed conflict?
I think my non-academic answer would be, hopefully it's the same, but it's situation-based. If you're doing a bombing, then you look at different parameters than when you're attacking an area where there could be collateral damage to civilians.
I tried to prepare legal examiners' answer to this question for the benefit of our discussion, but I found myself unable to. There may be no possibility of generalizing the differences of the principle of proportionality in armed conflicts in general and in law enforcement cases in general. So I think it's all the more important that the human rights body makes a decision ad hoc, on an ad hoc basis, considering all the facts of the case.
every time.
Yeah.
First, Dr. Fleck, the U.S. government announced that it was treating Article 75 as customary international law during
Thank
the
you.
Obama administration. So that's settled from the U.S.
Really for me, yeah.
perspective. And of course, I don't speak for the U.S. government now as a retired guy, but I think we would take issue, or most of us U.S. academics would take issue with the fundamental rights equal non-derogable provisions point. But what I really wanted to ask for both those that have served on international criminal tribunals on the panel and in the audience is, has there been a diminution or a lessening of expertise in the area of IHL application over the course of the international criminal tribunals, given at least in two examples, the OTP Kosovo opinion, which reflects a great deal of pure IHL analysis, versus the decision in Gotovina that kind of abandons a lot of the ex ante intent analysis that's in the OTP provision opinion, and takes a ex post analysis of effects that's not really covered in the IHL. Is there anybody on the panel or out here that has a view on that?
I've never read the Kosovo opinion. I wasn't there, but my colleague, I think, was, so he can answer the question. But in terms of Gotovina, are you talking about the appeal chamber decision, which I understand is totally political?
No, I'm actually talking about the trial court decision.
The trial court decision looked at the facts. The whole IHL case was quite complicated and quite well presented, with many experts that were consulted and gave testimony. But ultimately, you can only go with what you can get. But I think from I hear there was a lot of politicking going on at the time as to what the results in certain cases was going to be, and it was foreshadowed and actually came true, to the extent that even the legal test for aiding and abetting was changed because of the concern about the American government and its contribution to the shelling. But anyway, that's the little I know.
Vijay, no, I just wanted to say that it's funny. Back in the good old days, I would be at the bench looking at you sitting on your left. Now you're on the bench looking at me sitting on your left.
No.
But
I didn't even know if you sat on the cases.
I think that I too was prompted to ask Dick of making a clarification whether, Dick, you were referring to a trial judgment in Gotovina and Markic or appeals. Now, appeals judgment, although retired, I'll still try to follow some self-imposed rules of ethics. But look at Gotovina and Markic appeals judgment in light of another appeals judgment which followed very soon.
Yeah. Those were interesting times.
No,
I don't remember seeing you, so.
I will just speak very quickly, and of course, where cases are different from one to the other. and every case where you have to look into the facts. But as to the question of expertise, when I was in the tribunal, I should say, yes, we have. And for a lot of things where in connection with IHL, we have, where, for instance, where for our legal section, we have, for instance, where Mr. Bill Fenrick, who was originally from Canadian, and also where, as I said, where sometimes they are very much detailed, and then where you really need expertise, and then we also ask for assistance from the world. And even during trial, we also have expert witnesses. And for some very important issues, for instance, when we ask where some very high official were to come to testify from where, anyway, Balkan countries, I forget, Croatia where possibly, and also it concerned with some secret. And then where it comes out where a very important question, which is that the International Criminal Tribunal, which can summon the state or the state high-level official to come. So in that case, I still remember that this is really unprecedented. And then when the judge, Judge McDonald, who has a lot of experience in trial procedure, and then she realized that this is very important. And then when she issued an order that any expert, any government, so long as you wish, you may provide your views before the tribunal. So anyway, on the level of expertise, I can see that the tribunal is quite aware of that. Yeah, it's, well, how to say, I would say that the tribunal, when I was there, I feel all times it's really very professional. This is, I can say, yeah. Thank you.
All on the Godavina appeal, we actually moved to call additional military evidence to clarify that the judge at the trial division got it wrong. And we called a British expert, but there was, on every IHL case, there was the involvement of a significant team of in-house and outside experts.
Any other questions or comments? Okay, yes, our time has expired, and we can conclude our event today. And on behalf of the International and Comparative Law Research Center, I would like to thank all of participants for coming to Sanremo and to be here, and we hope that outcomes of our event will eventually support some positions of international court tribunals and who apply international humanitarian law and human rights law. And now I want to invite General Battisti. Yes.
Just a few words before closing. I'd like to thank all of you for your presence and for your very professional assessment regarding this non-clear at the moment interplay between these two bodies of law, because it's not a problem of academics or professional or judges, because there are always some problem for soldiers. Is the different nature of war, because we may have in the same place with different contingent, law enforcement, peacekeeping, peace enforcement, and conventional war. We have seen in Afghanistan many times, because in the same day, the same patrol can deliver humanitarian aid 2 hours later can have to react some ambush when they patrol Center Road, and then they have to keep under control some riot, urban riot, and so on. So it's not so easy for no one to assess and to react at this situation. Marco Sassoli state two important things. First of all, that nowadays there is no more rule applied in war. It is a sort of free field where each contingent or non-government forces can do what they want. We have seen in many countries like Libya, Syria, and so on, and Iraq. And then that one thing is a criminal behavior. That is a problem probably that you can add to the country, to the contingent commander, or not the country. The second thing is different, is a violation of a law that it could be done by a soldier or by a tactical commander. So it's very important. Closing, just a few words regarding the principle of proportionality. Of course, there should be a proportionality when a contingent, according to the rule of engagement, has to react against someone. But in my opinion and in my experience, sometimes is also a matter of interpretation, ethical and moral interpretation of the contingent regarding the same reaction, because it is a matter of culture, is a matter of tradition, is a matter of religion. So for one contingent, human being has a high value. For another contingent, I mean another country, human being has a different value. And so this is the consequences of a different reaction in front of the same situation. I give you a very short example. When I was in Somalia in 1993, at that time I was the chief of the JOC, Joint Operation Center, of the UNISOM 2 HQ. Every evening, every night, between 8 to 10 p.m., there were some Somali snipers that were firing upon the HQ. And the unit that was in charge to defend, to protect the compound, at every round of small arm, they react with a Milan anti-tank missile. So one bullet, one missile. One day during a morning briefing, the commander of the contingent, that was a Turkish general, asked to this lieutenant colonel, but I believe that you are using a heavy reaction when they fire just 1-2 bullets and so on. He said, sir, my government give me a task. The most important task is to protect my soldiers. So I react as I assess the situation. This is very important because there is always a national, presence, a national directive that is more important of international bodies, or international body of law, or multinational contingent directive. So national guidance or national caveat are more important at the end of the day. And finally, I suggest for all to see a movie that is very important because it explains clearly the controversial between this situation between soldiers, lawyers, politicians, and so on. It's a British movie. This is called Eye in the Sky. Have you seen this movie? Must be used also in the military school because it's very clear to explain all of this problem that happened. Very professional movie, Eye in the Sky. I give you, in Italy, of course, had another title that I'll explain you later. So thank you again. Enjoy this very few hours in this fantastic international city, because Sanremo is Sanremo. Thank you again.